and Ismail. My group and I today will present about law case titled Cases Carlill versus Smoke Ball Company. For the facts of the case, it begins when the defendant, who is known as Smoke Ball Company, Carbolic Smoke Ball Company, they published a newspaper on several advertisements saying that if anyone contracted influenza after having used their smoke ball as direction provided for a specified period of time, they can claim £100 in reward. And the claimant, who is Mrs. Carlill, she believed in the advertisement causes she bought the product. However, after using the smoke ball almost 2 months, she suffered from influenza. Then she claimed the £100. However, the company refused to pay, causing Mrs. Carlill sued for the reward. Next, the issues for this case are: first, since the advertisements are made publicly, the first issue is there a binding contract or not in relation to the reward between Mrs. Carlill and the Carbolic Smoke Ball Company. Second, the defendant argue it's just a mere puff. So, was there an express promise to pay £100, or is it just a mere puff? Third, if the advertisement is considered as an offer, does Mrs. Carlill need to notify her acceptance of the offer? And last but not least, in the contract of law, one of the conditions is there must have a consideration. In regard with consideration, does Mrs. Carlill give anything in exchange for the £100 reward?
We'll continue to the next part, which is the judgment and the reasoning.
Assalamualaikum warahmatullahi wabarakatuh. I'm Sharifah Athirah and I'm going to continue about the judgment and reasoning of this case. So for this case, the court had been decided to stay on the side of the plaintiff, which is Mrs. Carlill, which means that the plaintiff had won the case. Why? Because it is claimed that there is a binding contract in this case. So according to the first judge, Limli LJ, the advertisement issued by defendant is not a mere puff because of the existence of £1,000 of with the Alliance Bank's statement, and therefore it can be considered as a promise, although it is vague and uncertain. So in terms of the notification of acceptance, the contract consists of continuing offer. So the notification does not precede the action, which means communication of acceptance is not required in this case whenever the actions of the person demonstrate an intent to commute to the contract. So Ninli had pointed out two reasons of the view of consideration. So the first is because the first reason is Carbolic benefited from the smoke ball advertising as the sales become beneficial to them afterwards. So the second one is the direct inconvenience faced by Mrs. Carlill from using the smoke ball 3 times per day for 2 weeks, referred to the fulfillment of the conditions which made the promise became valid. So as a conclusion, the Lordship concluded that the defendant were being negligent to expose themselves to a considerable deal of actions, and it is the worst for them, which is the defendant. Okay, moving on to the second judge, which is Bowen LJ. So in contrary, the judge opined that the case is not too vague as everyone has their own perspectives on how they want to interpret the offer. So similar with Lindley LJ, the advertisement is not a mere puff, and it may apply to anyone in this world who sees the advertisement. So the contract will start once the people perform the conditions stated and come forward to compensate the offer. In contrast to Lindley LJ, the notice of acceptance is not necessary. So if the person fulfills the criteria, it should be inferred that from the transaction itself, that no notice of acceptance is required. So for consideration, the consideration of Bowen LJ is similar to Lindley LJ, which is the observation that there was a request to use in the offer between the offerer and the ones who were involved with the advertisement, which is the customers, and the inconvenience of Carlill's consumption of the smoke ball, which has resulted in experiencing a setback sufficient to warrant thought, as well as the benefits that defendants received due to the use of the smoke balls would encourage people to buy them.
My name is Siti Hazirah, 1923448. The third Lord Justice in this case would be Lord Smith. Same as Lord Minley and Lord Bowen, Lord Smith is taking side with both of the Lordship and agreed with their opinion. In his judgment, Smith stated that the conditions made in the advertisement was an offer intended to be acted upon, and when they acted upon and the conditions performed constitute a promise to pay. The offer in the advertisement, along with the performance by the plaintiff of the conditions specified, therein created a valid contract, supported by the consideration on the part of the defendants to pay the £100 mentioned in the advertisement, which explained the reason on why the plaintiff, Mrs. Carlill, was entitled to recover the £100, since she contracted with the influenza after using the smoke ball 3 times daily for 2 weeks. The Court of Appeal overall decision has decided to take side with the plaintiff. Hence, the appeal made by the Carbolic Company was dismissed. The reasoning was due to the fact that the contract has been legally binded, as Carbolic made an obvious offer to the public and Mrs. Carlill has accepted it. This falls under the law of a unilateral contract, where the promise in the acts made by the offerer is clear and the offer also has been communicated and accepted by the offeree.
Okay, my name is Putri Siti Hajar with metric number 1913492. Now I will explain about the analysis of the Carlill versus Carbolic Smoke Ball Company. Okay, based on that case, it is agreed that Mrs. Carlill won the case because there is a binding contract for £100 for Mrs. Carlill that was already made by the company. This is because the advertisement given is part of the unilateral offer for those who read the advertisement given. If the occurrence happened, the offerer, which is Carbolic Smoke Ball Company, should give what they promised to those who claim because the promise already happened. On that advertisement given, the offerer promised that their product will satisfy the customer, and this attract attention to the public because on that time there is a flu pandemic that killed more than 1 million people. More people buying smoke balls by relying on the advertisement was a clear benefit to the public. But once the public claims the offer that has already been made, the company should fulfill. If the company did not fulfill it, the public can sue the company since the binding contract has already been made. The Carbolic Smoke Ball Company also mentioned that they already deposit £1,000 at the Alliance banks, and it showed that it is serious attention to be legally bound. Here you can see that the deposit is called in aid by the advertiser as proof of their sincerity in that manner. In point of law, this advertisement is an offer to pay £100 to anybody who will perform this condition, and the performance of the condition is the acceptance of the offer.
My name is Husna and Ahsanul, and I will continue the next part of analysis. So the judgment in the case of Carlill versus Carbolic Smoke Ball gives a positive impact to the industry because now companies and advertising agencies are now more aware of what they are advertising. The marketing strategy that they use, be it physical or digital media, should be specific and realistic so they wouldn't have to face the general public issues. They should take note of how the law in the business works. It is important for the seller to be aware of their words since their sentences can be an offer to the reader. Such losses occurred in Carbolic Smoke Ball can happen for other companies if they are blind to this law. There are other cases involving unilateral contracts, for example, the case of Rafzan Fazren versus Hajar in 1925. So a son ran away from his house and the father made a pamphlet offering a reward of 500 rupees for anyone who finds him. The plaintiff happened to see his son, then took him to the railway station. He made a report and sent a telegram to the boy's father announcing that he had located his son. The Allahabad High Court held that this proposal was made for the word at large, so anyone can accept this proposal, and the performance of the conditions of a proposal is the significance of the acceptance. Hence, the plaintiff is entitled to the reward.
There is also another case in which Kellogg's popular Rice Krispies cereal had a crisis in 2010 when the brand made false claims in its cereal ads about the product's immunity-boosting properties. The Federal Trade Commission ordered Kellogg's to halt all advertising that claimed that the cereal improved a child's immunity with 25% daily value of antioxidant and nutrition, vitamin A, B, C, and E, stating that the claims were dubious. The case was settled in 2011. Kellogg's agreed to pay $2.5 million to affected consumers as well as donating $2.5 million worth of Kellogg's product to charity. In conclusion, in the case of the Smoke Ball Company, there is an attempt to trick the public into feeling confident with their product by giving a reward if the product fails, We can also conclude that the unilateral contracts can be made public and to the whole world at large. Moreover, there is no requirement for the party wishing to fulfill the condition to provide notice of accepting to the offer when conditions and rewards are used in advertisement.